This is the CitizenLink Report.
If you find our insights helpful, would you support our video efforts? Your gift of $25 or more goes a long ways. Covers the crew, lights, cameras, all that. Just click on Donate. Thanks from all of us. After Hobby Lobby was done, the Supreme Court offered a strong hint at how it would rule on all the other challenges still in play. This is the CitizenLink Report. I'm Stuart Shepard, along with Bruce House-Connect, who watches over the courts for Focus on the Family. Hi, Bruce.
Hi, Stuart.
The headlines for the past week have all been about Hobby Lobby, a few about Conestoga Wood Specialties, but what's gotten lost in all of that is that the Supreme Court did a little bit more before they finished up this session. Let's talk about what they did first, and then we'll talk about what it means after that.
Yes, in the smoke of Hobby Lobby on June 30th, kind of what was lost was they cleared up their docket of several other HHS mandate cases involving for-profit companies similar to Hobby Lobby and Conestoga.
So these are cases that have been appealed up to the Supreme Court that could have been considered by them.
That's right. That's right. There were such things as an HVAC dealer out of Denver, Hercules. We've known that one for a while, and an auto safety systems company from Indiana, a couple of food processing companies from the Midwest.
Yeah.
They've all wound their way through the federal courts and up to the Supreme Court. Some of them obtained the injunctions they sought at the lower courts, and some lost.
And by injunctions, you mean?
A temporary stop to the fines and penalties in the multi-millions of dollars that HHS mandate was going to impose on these companies for failing to offer an employee health plan that contained these abortion-causing contraceptives that they're all worried about, and they have a religious objection to.
So with that, some of the courts said, okay, you're protected while this case is being heard. Other courts said, no, you're still subject to the fines, which started this month, I might add.
That's right. So what the Supreme Court did was it took the cases where the contractors and the businesses had won, and it simply sent them back down to be finished. There's nothing for us to do here. We're not going to reverse it. In fact, we're going to send it back down. The injunction is in place, and you can go on with your trial and complete that trial.
Yeah.
Just like Hobby Lobby and Conestoga still have to do. There are still things to be done in those trials. And then in the cases that were before the court where they had lost, where they'd been denied those preliminary injunctions, the court did what we lawyers call a GVR.
I used to have a Pontiac GVR. It was a great car.
Yes, but
not that one.
You can't drive this one, but it basically stands for grant. They granted the petition to hear it. They vacated the lower court decision, meaning they threw it out, and they reversed, meaning they
remanded.
They remanded. Sorry, you know more law than I do.
I've been practicing.
And they remanded it back to the lower courts, and they said, do this again in light of what we just decided in Hobby Lobby.
So the grant means they formally take it up. Vacate means your decision is no longer valid, and remand says we're not going to solve this, though. We're going to leave it up to you guys based on what just happened with Hobby Lobby.
That's right, and of course, what are the lower courts going to do if the Supreme Court has already decided a legal issue one way against the HHS mandate? They're going to follow suit and grant the injunction and go on with the case, and probably those for-profit businesses will all come out successful.
Now, there were a lot of pundits after the Hobby Lobby decision came out who took some different viewpoints on this. Those on the liberal side of things tried to spin it in a way that maybe there was still a little bit of a silver lining from this decision. All this kind of says, no, this is what it is. The court says that corporations can have, in certain situations, First Amendment rights, including the freedom of religion and the free exercise of religion.
And that's perfectly right. And the other thing that they really objected to is they thought that the majority opinion in Hobby Lobby sort of said something that would impact the nonprofit side, all those religious nonprofits and churches and Christian universities out there. They thought the minority opinion in that case, plus all the pundits, thought that Alito was throwing his blessing upon the accommodation, as it's called under the HHS mandate, and that meant that the nonprofits would lose. But that's not the case because, the Supreme Court later that week suspended the HHS fines against Wheaton College and sent it back down to be tried. And all the lower courts are doing similar things with granting injunctions to the nonprofits as well as to the for-profits.
At the heart of this, and before we go on, I don't want to go into great depth on this, but at the heart of this is this simple question, and that is, as an American citizen, when I start a business or a nonprofit organization, do I then forfeit some of my First Amendment rights? What do you think about that question?
Well, the court answered that definitively in Hobby Lobby, and they said no. If you were a sole proprietorship, if you just owned it outright yourself, you certainly are recognized under the law as having religious rights. And if you were in a partnership, same thing. And the Supreme Court said there's no difference by simply incorporating your family-run business. That doesn't mean you lose your religious rights. There's no hierarchy in First Amendment rights where some people are more protected than others.
Now, you talked about, and I just want some clarity on this, there are two groups essentially left as far as the cases that are still making their way through the courts. They're the for-profit companies and the nonprofit organizations. Are they going to be looked at the same way, or will they be looked at differently as they come up, or do we know yet?
Well, the nonprofits are going to have some of the benefits of the Hobby Lobby decision. Some of the things that were decided clearly apply to the nonprofits as well, such as what the HHS mandate does clearly puts a substantial burden on everybody because the fines that the government is imposing are so huge. It's obviously a burden. It forces you to do something against your will. And the other thing that they said that the government had chosen in terms of the means they wanted to impose was not the best alternative for religious freedom values. Yeah. They could have done something else, and they pointed out a couple of things that the government could have done to accomplish the same policy goals. That will also apply to the nonprofits as well.
And that comes under, is at least restrictive means? Is that the right wording?
I'm teaching you well as we discuss these cases going forward.
I actually listen to you when you're out here.
That's exactly right.
That's the test, as opposed to the government being able to say, here's exactly how you're going to do it.
Right.
Now, up to this point, and before we wrap up to this point, we've talked about what the Supreme Court did, which signals its intent in the future. But we're also seeing what some lower courts are doing in reaction to what happened with the outcome of the Hobby Lobby case. Let's talk about that before we wrap up.
Right. Well, even in the last week or so, there are several federal courts from around the country that have been granting preliminary injunctions, especially to nonprofits. In Wyoming, a bunch of Catholic organizations got an injunction from the 10th Circuit.
Meaning they're protected from the fines.
Right. And Missouri, a district court judge there granted preliminary to another set of Catholic organizations in that state. The 11th Circuit on June 30 granted an injunction to EWTN, the religious TV network, and there are several others. The nonprofits are all, in the last week or so, scoring huge victories.
Now, does that show us what the outcome of those cases will be when they're fully heard, or does it just give us a little hint?
It gives us a hint, because the test for winning a preliminary injunction is not the same test as for winning the trial, but it comes very, very close. A court has to determine that you have a likelihood of success once the whole trial is over and the dust is cleared, because knowing what they know about the facts and the law at that point, you'd win.
All right. Anything else you'd like to share before we go? I appreciate your insights on this. It's very helpful.
I think we're probably going to see the next round of cases on this with the nonprofits come up in the next Supreme Court term that begins in October and ends in June of next year. So
all right. More to come, soon, as they used to say. All right, Bruce, thank you, and thank you for watching. We appreciate hearing from you. You may always write to us at mail@citizenlink.com. Do pray for all 9 of the justices on the Supreme Court. Find a list of their names. We encourage you to pray for them by name. Even the ones who don't necessarily agree with our point of view, it's still good to pray for our elected or for our officials at that level of government, and to pray that they would have wisdom and clarity and insight as they decide on these cases. And remember, stand tall and be heard.